Courtrooms are where the egos of some of the most corrupt cops come crashing down. Today, we will explore the most satisfying moments when these officers were exposed and taken down in court, just like this brutal cop who was taken to the cleaners for viciously beating an innocent man.
The court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000.
Sinister cops are always owned and exposed in courtrooms. Their true face is revealed for the whole world to see. Today we'll be going through such moments where these corrupt officers got some brutal karma that knocked them down. Euclid police officer Michael Amiot was on trial after he was charged with assault when he physically used force on an innocent victim after conducting a traffic stop. It didn't take long for karma to hit him.
We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of assault, a misdemeanor of the first degree, in violation of Section 2903.13A of the Ohio Revised Code, as charged in Count 2. We do so render our verdict this 29th day of July. We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of Section 2921.45A of the Ohio Revised Code, as charged in Count 3. We do so render our verdict this 29th day of July, 2022.
Rightfully, the corrupt officer was found guilty on both charges, and the jury did a fantastic job.
That is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
No, Your Honor.
On behalf of the defendant, anything?
No, Your Honor.
Yes.
Amiot showed no remorse during his trial, and the very next day he was called back for sentencing. To make matters worse for him, the judge allowed the victim to say some words in front of the court.
My name is Richard Hubbard, and I appreciate the jury and the court for making the right decision. What Amiot did to me was wrong. He should have received the maximum sentences today. I'm still going through the suffering with the anxiety, driving, just the temperament, the trauma, and everything. This is a cause for this case. I'm ready to get it over it actually, but just coming back in here, just bring up everything, and just to see him over there, see all this, just coming back in this court, it just brings up everything, you live at the moment. So, I hope you get the maximum sentences today,
This wasn't the end of it all, as the suspect, Michael Amiot, was also allowed to address the court and apologize. The cunning officer would still not accept his mistake.
One of the most shocking examples was a prosecution witness called who testified that I was celebrating in the aftermath of this arrest. They testified that I was high-fiving, fist-bumping, and dapping it up with other officers. There was 5 police cars on East 228th Street that day, all with their dash cameras on and rolling. They all had overlapping fields of view. I can be seen in front of one of those cameras the entire time I was on scene until I was transported to the hospital. Nothing remotely close to what the witness described happened with me or any other officer on the scene. They knew this and put the witness on the stand anyway.
There was no regret or remorse on behalf of Amiot, and it was clear that an apology was too much for this ego-driven officer.
I take full responsibility that there was a failure on my behalf to get Mr. Hubbard in custody quickly. The incident was prolonged when I was shot with a taser. During the deployment, I broke my hand, ruptured tendons, and injured my shoulder. I want to end by saying I'm not an advocate for or against use of force. Everything I did on that day was based on my training and experience. From here on out, I'll be an advocate for subject control training department-wide going forward so we can all be at our best when the time comes. I have a deep respect and love for the citizens and this community. I want to do my best to serve them.
Finally, it was time for the judge to speak, and before announcing the much-awaited sentence, he had some words for the officer himself.
One of the things that stood out to me is that the initiation of this incident probably never should have occurred. When you receive that initial radio communication. That initiated this whole thing. And the other thing that sort of stood out to me was that in approaching the vehicle and asking Mr. Hubbard to get out of the vehicle, there was an inability for him to get out of that vehicle without making contact with you.
The judge, who also happened to be a black man, spoke to the victim and assured him how he should move on from this terrible incident and not let the corrupt officer's actions ruin his life.
I believe the jury got it right. I do. And the court must impose the sentence that the court feels is appropriate in a case like this. And I appreciate if you need assistance, you need to go and get that assistance. But I'm not going to say you're not going to have instances of flashback or what have you, but you need to move on with your life also. And not let this incident continue to hover over you. The city compensated you.
Ultimately, the sentence was announced and Amiot was removed from the court.
Court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Mr. Amiot?
Just what count is this in?
The court will use the assault as opposed to the violation of civil rights. Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
He was initially sentenced to 90 days in prison, but that was later canceled. Instead, he was placed on 1 year of non-reporting community control and fined $1,000. He was also rightfully fired from the Euclid Police Department. This officer certainly earned his karma, but things took a bizarre turn when his qualified immunity was revoked.
He had nothing in his hands, and he was shot twice and killed.
In 2011, a simple traffic stop turned fatal when Officer Osvaldo Villarreal shot and killed innocent Benny Herrera. After a few years, his family filed a lawsuit against the cop, which eventually led to this pre-trial.
This is a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping
But if we're talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Shockingly, it only took a few seconds for the corrupt officer to draw his weapon and shoot innocent Herrera, although Herrera was unarmed at the time.
His camera was turned on, but
His
he
camera
testified.
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket." and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
To make matters worse, the officer had been cleared by the police department. It is shocking to realize the level of accountability that these cops have.
Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. Is he doing this peacefully? Or does he have something in his hand that could be a threat to me and is my life in danger?
Well, right.
He had a fraction of a second to make
Well, don't
that
we
decision.
have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities.
However, the body cam footage made it very obvious that the officer was in the wrong, and the judges also felt that his qualified immunity needs to go.
Here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. So, how is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know, with the benefit of hindsight, obviously, that was wrong.
It's truly saddening how Officer Villarreal was getting the cops' privilege. There was absolutely no reason to shoot the victim, and he should be getting punished for it. But thanks to the legal system here, he remained on the force without any trouble.
It seems like he had a better vantage point possibly than Mr. Villarreal.
He actually didn't, for these reasons. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex. Officer Villarreal fired toward a block wall.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine based on the facts as alleged by the plaintiff. And
Right.
they're gonna say, no, it was, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension. They rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You gotta stick with their facts and explain why under their facts, you win as a matter of law.
I agree, Your Honor.
However, things were now starting to look tough for the corrupt cop, and finally, the judges were reaching some sort of justice for the deceased and his family.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. Take those facts. You're
Yes.
saying that as a matter of law, the shooting here was legal.
Yes,
Those three facts.
it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident.
Okay.
He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
On
what
parole,
the
I
officer
don't
knew.
remember, on parole, they said.
On parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed.
The judges argued that the officer should at least be tried, as the other party had substantial evidence to challenge his qualified immunity.
Espinosa, the suspect, had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
The defense attorney worked hard to portray her client as innocent, but the judge wasn't having it and quickly shut her down.
The domestic violence incident was over.
Yes, and there,
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so.
it wasn't an ongoing domestic violence incident. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here is raised about the fact he didn't have a gun.
I understand. The trial court did.
After the defense presented their side, the plaintiff's attorney took the stage and raised several crucial questions.
But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Vial opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons.
The attorney made it clear that it was entirely the officer's mistake to escalate the situation to this alarming level.
Opposing counsel that he's entitled to make a reasonable mistake.
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version, and he had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief.
No matter what the defense argued, the facts were clear. Herrera was dead, and Officer Villarreal was responsible for his death. Still, the defense tried once more to sway the judges.
The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial, the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
The underlying predicate facts.
I understand that, but I think I'm arguing on your point. If we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
Once again, the judges stood firm on the right side of the law and shut down the defense attorney's argument.
Everything goes bad for your client. That is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives.
Next, we have this Border Patrol agent who made the biggest mistake of his life and was later owned.
At the Border Patrol checkpoint, your duties are to enforce immigration laws and look for terrorists and look for weapons of mass destruction and assist in detecting narcotics. Is that correct?
Yes, sir.
And when you do this, of course, you're following a procedure manual that tells you what to do?
Following policy, sir.
Written policy?
Yes, sir.
You have a copy of that written policy?
No, I do not, sir.
Have you ever seen a copy of that written policy?
That states our authority to conduct immigration checks, or for the checkpoint itself, sir?
For that checkpoint?
No, I have not, sir.
Are you aware of any written guidelines or policies or procedures on how to run that checkpoint?
I am aware that they're out there, sir.
You're aware that they're out there. Let me get this straight. You're testifying right now that you are aware that there are written guidelines and procedures for this checkpoint?
At the border, the cop wrongfully detained a U.S. citizen. When questioned by an attorney, the border agent struggled to defend the unlawful arrest.
Can you state that question again, sir?
Is it your testimony here and now that there are written guidelines and procedures for this checkpoint?
To my knowledge, yes, sir.
Have you seen them?
No, I have not, sir.
But to your knowledge, they exist.
Yes, sir.
Do you recall on June 1st of this year giving a telephonic statement to Mr. Victor?
I do not recall the exact date, but yes, I do recall a telephonic interview, sir.
Do you recall you were in a room with Mr. Katz?
Yes, sir.
I believe there was another attorney in the room who was a representative of the Border Patrol Union?
Yes, sir.
And you were on the telephone to Mr. Victor?
Yes, sir.
And you're aware that that tape recording was being recorded?
Yes, sir.
And were you trying to tell the truth at that time?
Yes, sir.
Do you remember being asked during that statement if you were aware of any written guidelines, policies, and procedures for this checkpoint?
The officer's lies were about to be exposed. A shocking call recording contradicting this previous claim was set to be played in court.
Do I remember that specific question, sir?
Yes, sir.
No, sir.
Do you remember saying that you were not aware of any written guidelines, policies, or procedures?
No, sir.
Would it help to refresh your memory if you heard a tape playing of your voice?
Yes, sir.
Your Honor, if I may? Tell me if this is your voice and if you remember being asked this question and given this answer.
And Your Honor, the state's going to object at this point. Was this noticed as part of your trial exhibit and disclosure?
Actually, Judge, this doesn't need to be noticed because it's impeachment, which is exactly how we're using it right now.
Your Honor, the same standard would apply to both parties. The state would expect everything that be given in notice to both parties.
Judge, the law's well settled in Arizona. If the defense had to give impeachment to the state of the state's witnesses before the state's witnesses testified, it wouldn't be much of impeachment, would it?
Just as the truth was about to be revealed, a shocking twist unfolded. Desperate to defend the cop's attorney objected to the evidence.
We're simply disclosing the audio tape of the interview that the state's witness, where the state's counsel was present throughout the entire interview.
Your Honor,
I have no understanding what possibly could be the objection to this.
Your Honor, may I have a moment?
You may.
Your Honor, Mr. Victor is quite correct under Rule 613B. The state withdraws its objection.
You may proceed.
Let's ask this question. Do you have any written policies, procedures, or guidelines on how the operation of that particular checkpoint is to be conducted?
No, to my knowledge, no. I'm there to reserve a citizenship, sir. If somebody's traveling through there and they come to our checkpoint, they're U.S. citizens, they're free to go. If they're not U.S. citizens, they say they are not.
Agent Gomez, did you recognize that as your voice?
Yes, sir.
Were you asked the question if there were any policies, procedures, or written policies, procedures, or guidelines for that checkpoint?
Yes, sir.
Was your answer that you were not aware of any?
Yes, sir.
Thank you.
State attorney's objection was swiftly withdrawn, allowing the defense to proceed with the audio playback.
To have your testimony correct that when people pull up and you ask them if you're a U.S. citizen and whether they answer yes or no, then they're on their way?
Yes, sir.
So if someone pulls up and you say, are you a U.S. citizen? And they say no, they're on their way?
No, sir.
Well, which is it? You just said if they say yes or no, they're on their way. But then I asked the question a different way. If they said no and you said they're not on their way, which one is it?
Usually if somebody says no, they already have their immigration documents with them. They present that to me and they're on their way.
And do I have your testimony correct that if you are unable to determine citizenship at the checkpoint, do you usually try to get them to go to secondary?
Yes, sir.
Not all the time?
No, sir.
So sometimes you cannot determine citizenship at the primary, but you just let them go?
No, sir.
And now I'm confused again.
The attorney's skillful questioning quickly exposed the officer's lies. The unprepared agent was no match for the legal expert.
You are unable to determine citizenship at the primary checkpoint. You usually try to get them to secondary.
Yes, sir.
I did not say always try to get them to secondary. Do you understand my question?
Yes, sir.
Usually means sometimes not, doesn't it?
Yes, sir.
So is it fair to say that Sometimes, if you are unable to determine citizenship at the primary checkpoint, that you let them go anyway.
No, sir.
I don't understand again. If someone comes up and you cannot determine citizenship, you say you usually try to get them to secondary. Is that correct?
Yes, sir.
Usually means not always. Is that correct?
Yes, sir.
Like, I usually wear a suit to court, but not always. Do you understand that?
Yes, sir.
Now the attorney turned his attention to the real victim, exposing the officer's true colors in a devastating display of legal skill.
So there are some times that people come up and you are unable to determine citizenship, but you just let them go on their way. Is that correct?
No, sir.
And what do you do with them?
I try to establish the citizenship there.
And suppose you can't.
And they go to secondary, sir.
So if you are unable to determine citizenship, they always go to secondary.
Yes, sir.
Not usually, but always now.
Yes, sir.
Mr. Anderson was sent to secondary inspection because of the dog alert. Is that correct?
It was a combination of both immigration and the canine alert, sir.
Okay. So you're saying part of the reason he was sent to secondary was immigration, not
Yes.
the dog alert?
Yes, sir.
But wasn't the decision made to send him to secondary, wasn't that decision made before he ever got to you?
Yes, sir.
And the decision was made, or you got the signal from Agent Spoonamore,
Correct.
before any immigration question was asked.
Correct.
And Agent Spoonamore gave you that signal because his dog alerted.
Correct.
The cop's downfall was imminent. He had been discredited twice previously and was now facing the final reckoning.
So the dog decided to send him to secondary.
Correct.
How does the dog determine immigration status?
The canine does not determine citizenship, sir.
So he wasn't sent to secondary for immigration. He was sent to secondary because the dog alerted.
Mr. Anderson never answered my immigration question.
But the decision that he was going to secondary had already been made, correct?
Correct.
He could have pulled up to that primary checkpoint with a passport in his hand, and he was still going to secondary. Is that correct?
Correct.
The lawyer wasn't finished yet. He exposed and defeated the cop with a forceful statement that silenced him.
Is there any better documentation of U.S. citizenship than a U.S. passport?
No, sir.
So it didn't matter what he said, he was going to secondary.
Yes, sir.
Because the dog said so.
Because the canine alerted to the vehicle, sir.
Is a canine trained to alert to people here illegally?
No, sir.
So the dog wasn't alerting for immigration.
The cop was brought down by the lawyer's unwavering dedication to justice and the truth. The illegal stop was exposed and the officer was forced to face the consequences of his actions. This officer's arrogance cost him everything. But wait until you see what this next cop did. It is almost unbelievable.
Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law.
In a shocking turn of events, Indiana State Police uncovered a massive embezzlement scheme involving Clark County Sheriff Jamie Knoll. The sheriff was charged for stealing more than $5 million from taxpayer funds.
Date of birth?
12/18/70.
Make you know?
52, sir.
And the last four digits of your social security number? What's your address?
3001 Old Tate Road, Jeffersonville, Indiana.
You have a good contact telephone number?
Yes, I do.
Can the drugs include alcohol, sir?
No, Your Honor.
Do you understand English language?
Yes, Your Honor.
Let's say something you don't understand. Will you let me know?
Yes, Your Honor.
Mr. Knoll, Special Prosecutor Pearl has charged you with 15 counts of criminal conduct. I'm going through them. Count 1. Corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1, that on or or about a period of time from November the 9th, 2018, and August the 16th, 2023.
The action was taken quickly when Knoll's offenses were exposed. With a startling 25 criminal charges, he was immediately removed.
Clark County, state of Indiana, you did knowingly or intentionally through a pattern of racketeering activity acquire or maintain, either directly or indirectly, an interest in or control of property or enterprise contrary to the form of the statute in such case made for life. Count 2, theft as a level 5 felony. It would indicate that pursuant to Indiana Code 35-44.1, you then personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4-2A, would indicate that between April the 30th, 2021 and September the 14th, 2022 in Clark County, state of Indiana, you did knowingly or intentionally exert unauthorized control over the property of Utica Volunteer Firefighters Association.
The investigation took a dramatic turn as authorities discovered evidence connecting Knoll's wife, Misty, and daughter, Casey, to the embezzlement plan.
On or about August the 16th, 2023, in Clark County, state of Indiana, you did knowingly or intentionally alter, damage, or remove any record, document, or thing with the intent to prevent it from being used, produced as evidence in any official proceeding or investigation. That being, you factory reset your phone upon the arrival of the Indiana State Police on your property. You, in your capacity as Clark County Sheriff, public servant, did knowingly or intentionally assign to Rodney Walker, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve. That being sheriff, assigned Walker duties on your personal property, rental properties, father-in-law's property, pole barn, property of Utica Fire Department.
It was a shocking revelation that made people wonder how the sheriff, who was obviously breaking the law, managed to maintain his position for so long.
And count 15. Official misconduct is a level 6 felony and would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being Sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being goes to employment as Sheriff of Clark County relating to Brent Fisher. Mr. Knoll, the first 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail if treated as a misdemeanor to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand what you've been charged with?
Yes, Your Honor.
Do you understand the potential penalties?
Yes, Your Honor.
As the judge read out the 15 devastating counts against him, Janey sat calmly. The courtroom was tense as the state attorney argued for his detention without bail.
The next question is usually, do you intend to hire a lawyer? But you obviously have counsel seated with you. I need to tell you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, see their question and cross-examine those witnesses. You have the right to have witnesses brought into court to testify on your behalf. And at your request, the court will issue subpoenas requiring those individuals to come into court to testify on your behalf or to bring evidence in. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to remain silent. You cannot be required to give any testimony or make any statements against yourself to anyone.
The court defied expectations by granting Janey bail, a move that would later turn out to be a serious mistake.
He will surrender all firearms except one shotgun of his choice to Indiana State Police. Being from the country, or as Mr. Wilder said, Washington County. I keep my shotgun with double aught near me, along with a 45, but I think one shotgun for personal protection is appropriate for him to maintain. Will not leave the state of Indiana without permission of the court, and they'll post $75,000 in cash. Mr. Knoll, Mr. Wilder, I know you want to be released without posting any bond, but it's a unique case, and you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge, so please.
The judge, in a firm and decisive tone, made the decision quite clear, leaving no room for doubt or misinterpretation.
You keep one shotgun only. Try to deceive me, you will not like the consequences. Understand? Yes, Your Honor.
And then, Judge, the issue of return of all other items, see if we just take them in another hearing.
Well, it wasn't set for today, so
no.
Yeah, we'll deal with that at another time. I assume now that everything's going to be unsealed, there'll be a lot of new things brought before the court that we'll address in due time.
Thanks, Judge.
Anything else?
No, Your Honor. Nothing else from us, Judge. Thank you.
All right, let's be off record. Thank you all.
After police discovered concealed firearms, Jamie broke his bail terms and was taken into custody again. This time, the judge delivered a severe warning.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him.
As the judge delivered his sentence, he took a moment to highlight the shocking fall from grace of the former sheriff.
You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wilder.
Sure.
Or Mr. Boyles, I apologize, Mr. Boyles, your lead. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find it, Mr. Ertle's original argument that he was trying to make that I sustained, an officer of the law. Every time I go into court, I hear, I didn't know it was there. I didn't know it was there. I really did. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It's your burden. It's your responsibility. And today, the court will enforce that. Take it on.
Moving on, nothing comes close to this predator cop who received a life sentence.
Count 28, the first degree. Defendant is guilty of the crime of rape first degree, and punishment is set at 30 years.
This is Officer Daniel Holtzclaw, who was sentenced to 263 years in prison. Today we'll uncover the chilling story of his crimes and how he was ultimately exposed and brought to justice in the courtroom. Make sure to watch until the end, as the disturbing details will leave you stunned.
Do you recall putting your penis in her mouth?
I don't. I didn't see her breasts.
It all began on the night of June 18, 2024, when Holtzclaw was heading home after completing his shift. That is when he conducted a traffic stop of a 57-year-old woman, Janie Ligon. During the stop, the officer made her lift her skirt and pull her pants down before forcing her to perform oral on him. The very next morning, Janney headed over to the Oklahoma Police Department, and as Holtzclaw came for his shift the next morning, he was greeted by detectives Kim Davis and Rocky Gregory for interrogation.
Tell me about that stop.
I was going westbound on Northeast 50th, probably a block just east of Lincoln. I see a red Grand Prix or Grand Am in my right lane, in the outside lane. I'm in the inside lane. The car swerves, and so at the time I'm thinking, okay, it's probably a drunk person, or maybe he got excited because they saw a cop. Made contact. It was a black female. Asked for license and insurance. Stated that she didn't have insurance. Gave me an ID.
Do you make traffic stops normally after work?
I don't, but in that case, I saw her swerve and whatnot, so
I mean, me, I don't.
Felt.
After I get off work.
I know. I mean,
I know,
people,
the last thing I
cops
want
say
to
that
do
as
right.
have a, you know.
At the time of the stop, Holtzclaw had illegally turned off his GPS and patrol car computer, a clear violation of protocol. Detective Kim Davis quickly realized the seriousness of the situation and began investigating the alarming allegation.
Okay, so you got her out of the car?
Yes.
Okay. And put her in the back of your car?
Yes.
Okay. Any problems there?
No, she was cooperative. Didn't give me any problems or whatnot.
Did you run her on your MDT?
No, I didn't. All my stuff as far as that, because I didn't call it in and say it was a traffic stop. My computer was off and everything as well.
Did you shut it off?
I just shut it off.
work?
Yeah.
When you put her in your car, did you pat search her?
When I came here, I was like, lift up your shirt. Is there anything on you? Anything as far as your waistband or anything like that? She said no. And then I put her in the vehicle and went from there. Asked her everything.
Did your hands go on her at all?
I backhanded her on as far as the side.
Where on her body? Tell me. You backhanded
Her waist, and the back portion. I didn't touch her butt or anything, but the back portion of the waist. And then she lifted it up like right here, and there's nothing.
Did she lift it up like this?
No.
Okay. So she never, like, went, whoo, nothing,
No.
exposed her breasts or anything like that?
She asked me if I was like, no, it's okay.
The Predator officer appeared quite calm and composed, having no clue that his dirty secrets were about to be exposed.
Saying it was the hip, the side, not the section.
What about right here?
No.
You didn't?
No, I didn't.
They can tuck a gun
That's
right here.
why I asked to lift it up.
Oh, so she just kind of showed you her belly?
Right.
Okay. Well, was there anything, an accidental touch, anything?
If she thought it, when I passed searched her, but it was nothing as far as I felt like I would do anything as far as anything like that. For my safety, I just checked to see the weapons or anything. To make clear, I didn't touch her butt by the waist side and whatnot. If you would like me to do it for me to show you.
No, and I'm fine with it, and you have every right to do that. She's saying that you made her lift up her shirt, and when she lifted up her shirt, she exposed her breasts.
No.
You'll be shocked to learn that this wasn't the first time Officer Daniel Holtzclaw had abused his authority to intimidate and assault women. A multitude of black women soon came forward with similar allegations, exposing the true extent of this predator's crime.
She said, she said she was doing this. When you said, is there anything inside your bra? And she was going, no, I don't have anything like that. Did she do that?
Yeah, she did, but I didn't look or anything like that.
Right.
And then she was like, do you want me to show you? I was like, no.
She said when she said, do you want me to show you? You said, yeah, and she went,
woo. No, I didn't.
But could she have been, woo, flashing you? And now you don't want to tell me because you're afraid you're going to get in trouble?
No, when I told her no, I said no.
Then she didn't go, yeah,
No.
you know, because sometimes drunk girls are
having a good time.
Yeah, but I'm asking you if she flashed you anyways.
I didn't see her. I didn't see her
no
breasts. I didn't see her breasts.
Okay. What about pants?
Nothing in her pants as far as that concerned. She was wearing tight jeans. So
She said she pulled them down.
I didn't see it.
You didn't see her pulling down?
I didn't see her pulling down pants. Did not see
You did
her
not see her
breasts.
boobies.
No, I did not see her breasts.
So she's saying you shined your light on her.
I did not see her breasts.
Where do you keep your flashlight?
The left side right here. Right.
Detective Kim didn't hold on to the questions and laid out the allegations made by Janney. Shortly after, the other detective collected a swab to obtain Holtzclaw's DNA, as the woman had already submitted to a sexual assault exam.
Maybe a little bit over 5 minutes. Maybe like 5 minutes if.
So you're with her for 10 minutes. Did she say
Nervous.
why she was crying?
She says police officer and whatnot, and I'm just nervous because I got stopped by a police officer. So I'm like, calm down, everything's fine. And then, so I think maybe with the fact that she had no SDL, maybe she was nervous as well too. And then so.
Ralph, what time is it on your watch? I turned my phone off. So.
I've got 4:47. What I've got. So do you usually do traffic stops on going home, or what was?
I don't. Like I said before, I really rarely don't. I usually try to get home because I'm tired of them and
Well,
shit.
and are you a big DUI worker?
When I first started coming out, I did. But not really at the end now, to be honest with you.
I usually, if I see somebody swarming, I'm whoop, the other way.
And that's what a lot of officers do too, so.
Well, Daniel, this is kind of one of the things that we kind of bring you in here to see how truthful you are.
Right.
Now you need to kind of think of a few different things here.
Okay.
Okay. We pulled up a lot of video around that area after these allegations.
Okay.
Okay. She also had a SANE exam, which you know what that consists of.
Right.
There's a reason why we wanted your buckles. So if we go off the video and watch that, you're still going to stick with your story.
Yes, sir. As far as that,
Do you recall putting penis in her mouth?
I don't.
Would you recall that if you did it?
If I did, yeah.
The officers had also gathered some CCTV footage of the incident, and although nothing was clear, it showed that Holtzclaw's car had been there for over 25 minutes, which raised several red flags.
We knew you were on that stop.
Right.
We knew you were there. And we can watch a whole lot of actions being performed while you were there. Okay? And that's why she was trying to give you every out on the whole booby thing.
Right.
But any reason why your penis would be out?
No.
But if we say, we didn't do it, and then the DNA comes back and says, he did it, then we have a huge problem.
Right.
Okay. On the video, are we going to see her boobies?
Shouldn't see her boob. See her.
Okay. Are we going to see her pull her pants down?
I didn't see her pull her pants down.
Are we going to see your penis out?
Nope.
Are we going to see your penis go in her mouth?
No.
Are we going to get any DNA to that?
No.
Shortly after, Detective Gregory dropped another bomb on Holtzclaw. Just a month ago, 43-year-old Terry Morris told the cops the same officer had found a crack pipe in her car and had threatened her with jail. He then asked her to expose herself and give him oral sex.
Probably not necessarily going to remember the name, but her name is Terry Morris. Okay, black female. Supposedly you promised her a ride to the city rescue mission. This ring a bell?
No.
She thought you ran for warrants. Was it clicking? Drove her around. No.
Name doesn't. I don't recall a name like that.
Okay, she's claiming the same thing. The exact same thing. And here again, for whatever reason, things are pointed at you again. Traffic stop, not logged in, all that stuff. Okay. How about any stops of a person just walking, even just downtown? Anywhere downtown?
No. I don't, in Spring Lake, I don't go downtown. Besides if I go to Classen, not Classen, but Western and Maine to Valero's. To
Or the jail.
Or jail.
Or
That's
headquarters, property.
Right.
And you just don't remember doing any of those type of stops?
No.
Not in the last month or so?
No.
Do you run everybody that you come in contact with?
Majority of the time.
But you didn't run old girl this morning?
The 50th.
50th in Lincoln.
No, I didn't. I didn't run her.
The other girl that he's talking about is kind of making the same allegations, and that's weird.
Yeah, that
doesn't look good. I mean
that's
it doesn't
weird.
look. Yeah, it
That's
doesn't look
weird.
good. So, no, I don't.
Holtzclaw denied any connection to Terry, but a pattern was emerging, targeting black, poor women with legal troubles, and the list was growing.
What to think? Would you take a polygraph?
Yeah, if you want to take a vote.
I mean, I'm trying to think of the solution. Do you know how slow DNA is?
I don't. I do not.
Slow.
When you went home, was anybody home?
My girlfriend was home.
Do you live with her?
Huh? No, she doesn't. She just stayed.
Did you get laid?
Messed around, yeah.
What's messed around?
I guess
We were all adults.
we almost had sex, and she was tired.
What'd you do?
So my penis went around her vagina, and then maybe went a little bit in, and then she pushed me off and said, "No, we don't want to. I'm tired." I was like, "Okay."
That's kind of mean to let it get that far and then stop.
So
that's when you got home?
That's when I got home.
The detectives then started asking the officer some personal questions, which would eventually help them in the long run.
How often do you have?
About once a day, if that.
You guys have sex once a day?
Yeah.
How old are you?
27.
Well, yeah.
How much did you?
Maybe once a day.
So you sex once a day and masturbate once a day?
Yeah.
What'd you do when you got shot down at home today? Usually you got to relieve that.
Right. That's
I know.
that was before work. That happened before work.
You masturbated before work?
Yeah.
The detective returned to the topic knowing that she wouldn't be leaving soon. Despite the hour-long interrogation, Officer Holtzclaw remained calm and composed, showing no signs of desperation or anger.
If she goes like this, well, she's going to be looking right at you.
Okay. But it was just talking.
Let me ask you this, did you ever get a hard on when you were talking to her? Because she could have...
I don't think
These
I
pants
got.
don't fit the greatest,
Right.
and if you get a I'm going to be able to tell you got a
Right. And I'm pretty positive I didn't get a hard.
Didn't get a hard on when you talked to her? Did your pants come unzipped, unbuttoned, anything while you were standing right there?
No.
CSI is processing your car right now.
Right.
And when we stepped out, they found some pubic hairs right in here. Could they be yours?
No, that's not. I didn't pull my penis out. I didn't do anything right there.
Did she?
No.
But do you think they could be?
No, it's not. No. Nothing on mine.
Your pubes couldn't be
No.
right there?
No.
There was now shocking evidence gathering against the officer, and by the end of this week, he would be facing rape accusations from 8 different women, including a 17-year-old minor.
You sure she just didn't flash you?
I can't. She did not. I want to say I can't recall, but I'm pretty positive she didn't flash.
I see
me. She went like this, but nothing as far as I'm going like crazy looking.
Lifting the shirt.
No.
How far did she lift it?
She lifted it up first when I patted her down. She was like right here to her stomach line.
Did you see her belly?
Maybe some fat rolls or something. I don't know, but nothing.
Right, but I mean, could you see skin?
Yeah, I saw skin. Yeah.
You like older women?
I don't.
How old's your girlfriend?
She's 25.
Okay.
What's the oldest lady you've slept with?
Maybe 29.
You ever slept with a black woman?
I have. In high school, I have.
Okay.
Why would she make? Because when a woman says something like this, and they go through a sane exam, and they get, you didn't give her a ticket, so she's not getting out of a ticket. You didn't arrest her, because we get those when they go to jail. I've been raped. Work those stupid things because they think they're going to get out of jail.
Right.
The detectives had no reason to doubt the woman. She had nothing to gain and wasn't even ticketed during the traffic stop. The odds were stacked against Holtzclaw, and he had little to defend himself.
Anyway, those pubes are going to be yours.
No, they're not. Please. Go.
I know. We're going to test it. It just takes. Anyway, your skin cells are going to be anywhere on her mouth.
No.
Skin cells from your fingers.
No.
Did you touch her body anywhere other than with the back of your hand pat searching her?
Just pat search her, and that was about it. Didn't touch her face or anything. Right.
Because if the tests come back, you ain't coming back in here.
Because we have a woman that says about, basically being assaulted.
Right.
Okay, and we're calling it by force and all that. Big difference between that and a hookup.
Right. Nothing else.
But when she was standing, did she try to pull her pants down?
No.
Did she do, you said she kind of did like
did
this.
this.
Did she ever do anything down here?
No.
You said you take the lie detector test.
Right.
Do you have any extra job? Is there a time when you can't take a lie detector test?
No.
You're saying about 15-minute traffic stop. How long do you usually take on a traffic stop, just on average?
Maybe 20 minutes.
It was shocking how Holtzclaw stayed calm despite being asked questions that would anger most officers. He kept denying everything, hoping his badge would protect him again.
20 minutes. Now that's going to be some 800 time, right?
800, searching the car in detail, all that.
Okay, so doing all of that, all the running, waiting in line, and even on a search. Now, the question I have is we got a lapse of time here, so I'm kind of get a better handle on where the time went. You're talking about 15 minutes, no 800, no running on the computer, you shut it down. And you said it was just a quick little search of the car. Where's the rest of that time?
Just talking to her.
About what?
Just see
I mean,
where you
she's-
go and trying to try to get her to confess. Are you drunk or not? Like, are you been drinking? Because I could smell it when I was in the car, but I can't really get.
Well, what if she said, yes, I'm drunk?
I didn't hear a lot of drunk questions, like how much
Have
did
you been drinking? Mainly it's just have you been drinking, try to get her confessed, see anything inside that juice. But,
Okay, right there, those questions maybe took 40 seconds. 15 minutes?
And you said 5 at the car. So then we got 10 of a lot of questions.
Right.
Okay. I mean, you tell me I wasn't there. I mean, obviously I don't have any audio.
And that's what I'm saying. Roughly on a traffic stop, take about 20 minutes.
Time was a key piece of evidence. Holtzclaw didn't issue a ticket or run her name, but spent 15 minutes talking to her. Something was clearly off, and the detectives were closing in.
How could you take 15 minutes on that?
Just talking. I must have been talking. So.
I can't see her wanting to talk if she's crying and asking if you're going to and all this. I don't see her being real forthcoming with conversation.
Whether my questions or whatnot, that's it.
I mean, you don't seem. I mean, I don't know how you were out there, but just kind of talking with you. I mean, you seem real laid back and everything like that. I've never got the impression of just kind of an angry type cop. We know some.
So you don't think 15 minutes was too long on that traffic stop?
No,
And nothing sexual went on during that 15 minutes?
Nothing sexual.
Detective Kim left the room, leaving Holtzclaw alone for over 10 minutes. When she returned, she had proof of the first of many lies that he had told.
I just talked to Karen.
Okay.
She said she was asleep when you got home and you did not try to have sex, and you did not have sex.
Did try to have sex.
She said you didn't. And I asked her, could you have been asleep? And you had kind of, no. And she said no. You did not try to have sex.
As much as I don't want to involve her, I tried to have sex with her and she was asleep. Carrie goes to sleep pretty early, about 9, 10 at the late.
Okay, but she would know if you tried. I'm a woman.
I know.
And my husband comes home in the middle of the night and I'm like, are you kidding me? I've been asleep. You said you twirled around her vagina.
I did.
And you put it in a little bit and then she said, I'm tired. No.
I did.
She would remember that to tell me.
Maybe.
She said you did not try to have sex.
The officer's actions really weakened his case, as he was now caught lying about the very first statement he made about that night.
I don't know what to say. I mean, because it just looks like I just caught you in a lie. And now I don't know what to believe.
I'm telling you.
I don't know what to believe.
Okay.
Because you tell me this, I go to verify it. She tells me the opposite, and now I'm wondering what you're telling the truth about.
Maybe because she doesn't know what the heck's going on.
No, she doesn't. I didn't tell her.
And I'm glad, but detectives calling her, any other officer asking her a question like that.
I know.
She made me scared. I'm telling you, I tried to have sex with Carrie, my girlfriend.
She is going to remember your ween twirling around her hoo-ha. You remember that. I'm sorry, I don't care how much of a sleeper you are. You remember because it pisses you off in the middle of the night and you go, are you serious? Don't bother me with that.
The interrogation ended with Holtzclaw being placed on administrative leave and ordered to surrender his uniform, badge, and gun. His uniform was immediately sent for DNA testing, a crucial step in the investigation.
Looks like you're gonna need to, unless you want to keep the shirt on. I don't know. I don't know if this shirt's gonna be big enough for you here. There you go, boy. Why don't you go ahead and get dressed then?
I need to tell you what's going on. It's crazy. I said I'm basically on my way home, and I'd like to talk to you. What's going on? It's crazy.
Shortly after this, Detective Kim tracked down 6 more women who made the same claims against Holtzclaw. One of them was identified as 17-year-old Adara Gardner, who claimed that the officer assaulted her on her mother's porch. Shockingly, her DNA was found on the opening of the zip of the officer's pants, which were taken in for investigation. This almost sealed the deal, as he was ultimately facing 36 charges, including battery, assault, oral and stalking.
1. Battery. We, the jury, impaneled and sworn in the above entitled cause, do upon our oaths find as follows. Defendant is guilty of the crime of battery and set punishment at 8 years. Count 2, procuring lewd exhibition. Not guilty of the crime of procuring exhibition. Defendant is not guilty of the crime of battery. Count 8, defendant is guilty of the crime of forcible oral assault and punishment is set at 20 years. Count 9, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree.
Holtzclaw pleaded not guilty, claiming the women were motivated by monetary gain. However, on December 10, 2015, after a lengthy trial, the jury delivered their verdict. A jury of 12 white people were selected, who found Holtzclaw guilty on 18 charges. The officer kept weeping throughout the conviction as if he hadn't done anything wrong.
Count 16, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy. Punishment is set at 16 years. Count 17, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 18, procuring exhibition. Defendant is not guilty of the crime of procuring exhibition. Count 28, rape degree. Defendant is guilty of the crime of rape first degree and punishment is set at 30 years. Count 29, rape first degree. Defendant is guilty of the crime of rape in the first degree and punishment is set at 30 years. Count 30, battery. Defendant is guilty of the crime of battery and punishment is set at 8 years. Count 31, in the second degree by instrumentation. Defendant is guilty of the crime of rape in the second degree and punishment is set at 12 years.
Holtzclaw was fired from the police department, with the chief of police calling it the worst abuse of power in his 36-year career. Leaving the courtroom in tears, Holtzclaw repeatedly said, "I didn't do this."
Mr. Holtzclaw, this jury finds you guilty of the various counts. You will be remanded to the custody of the Oklahoma County Sheriff for formal sentencing set January 21st, 2016 at 10 o'clock a.m.
All right, that's hold the jury.
All right, you have a seat.
Eventually, he was sentenced to 263 years in prison, and since then, both the Oklahoma Court of Appeals and the United States Supreme Court have denied an appeal to uphold the prison sentence. Well, this brings us to the end of this video. The case drew extensive media coverage and sparked protests across the city and outside the courtroom, reporting the poor black women who had been brutally abused. It was shocking how a law enforcement officer used his authority to commit such heinous crime. Thankfully, he will be spending the rest of his life behind bars. If you agree, please support us by liking this video. And if you enjoyed this video, be sure to check out these moments when corrupt cops were caught illegally arresting innocent people.
Your vehicle is not like that. Sit down. No. You sit down. Get on the ground.